Hello world, welcome to Legally Blind Jimbo Yoakum, and today we're going to be talking about successions. What is it? What kind are they? But first, let's cue that intro. All right, successions, putting the success in successions. Yeah, that's a stupid dad joke, whatever. Successions, what are they? In Louisiana, when someone goes on to meet their maker, across the chilly Jordan, goes on to be with the good Lord, as we say down here in the South, what happens to their property? Other places call it probate, and that's kind of true in Louisiana. There's a probate process, but the property must succeed to the next generation, hence a succession. And so, whenever someone passes away, you have certain assets that have to be dealt with, and that process is through the process, as I said, of successions in Louisiana. And so, it's not something that necessarily happens automatically. The devolution or transfer of ownership happens automatically, but to record it and to make sure the law recognizes it, that requires you filing certain paperwork with the court. So what happens whenever your loved one passes away? You don't necessarily have to wait until the death certificate comes in. That's always helpful because it has all the information in one location and then all that, but it's not necessarily required to start the succession and probate process. But let's talk generally about what goes on. There are pretty much three types of succession. Testate, meaning the person has a last will and testament, testate. Intestate, no will, intestate succession. And as a subcategory of intestate successions, we have what are called small successions. So we'll break those down very quickly. A testate succession, if someone has a will in Louisiana, it has to have first off, it has to be enforceable, must be an enforceable will. Louisiana has very strict requirements concerning notarial, notarized wills, and what are called holographic, spelled like holographic without the H. In fact, in other states they're actually called holographic wills. But we're different here in Louisiana, and we want to take the H off just so we can be different. And so we have holographic or olographic wills, which are handwritten. They have very strict formats. We'll do a video about that later on, so if you want to know that, check out those other videos. But let's just assume the will is enforceable no matter what form it is. You first have to file a petition to probate. That petition to probate will go and brings the will before the court, and the will is recognized as being enforceable. So the first petition is one that makes sure the will is enforceable under Louisiana law, and it's a will in valid form, yada, yada, yada. Assuming it is, you then later file your petition for possession. That is where you say, hey court, the will is enforceable. The will said Johnny and Susie get X, Y, Z, and now we're asking that you send them into possession of it. A petition for possession. Ultimately, you'll be giving the judgment of possession, the JOP, judgment of possession, and that's what you'll take to the banks and all that to get the property released to the rightful owners or legatees. Another fancy word, anything that's left to you is a legacy, and if you receive a legacy, you're a legatee. And so we'll make sure that those legacies get to where they need to go through the judgment of possession. If it's an intestate succession, meaning no will was done, or the will that was done on some sketchy website, printed offline, Aunt Susie tried to do it herself, and it's not enforceable. The law says, okay, throw it in the trash. You have to go by intestate succession, which means that the law has a preset set of rules that are going to determine who gets what property. So mom and dad have 3 kids, dad passes away, they have community and separate property, meaning property that was acquired prior to the marriage or was inherited, generally speaking. And so it's a separate piece of property. It wasn't something that they bought while they were married. All that will go to the 3 kids outright. They get the separate property from dad. Community property, see another video on community property, but pretty much anything that's acquired during the marriage by mom and dad. Community property, the dad, who's now deceased, his half ownership interest will go to kids with a spousal usufruct, keyword usufruct, in favor of mom, the use and fruit in favor of mom under Article 890 Louisiana Civil Code. So mom has the 890 usufruct, meaning mom has the right to use the property and the fruits of the property. Could be rent, could be literal fruit, apples, oranges, whatever. Basically, kids can't kick mom out unless she gets remarried or goes on to be with the good Lord. But they can't kick mom out, and they can't access it. The kids are what are called the naked owners. You heard right, naked owners. meaning they own the they own dad's half the property, but they really don't have too much of the rights that are associated with it as long as mom's alive and not remarried. So that's an intestate succession. Subset, small successions, probably could be a video in itself, but a small succession is when the value of the assets that are owned by dad, who's deceased, if they are valued at less than $125,000, so check one, was all the property dad had valued less than $125,000? Next step, is it intestate, meaning dad didn't have a will? If it's intestate, less than $125,000, you can do a small succession, which rather than filing a petition with the court, is an affidavit that the heirs all sign. They say, all the heirs come together and say, all these facts are true. Daddy's passed away, see the attached death certificate. Daddy didn't have a will, and here's the property listed. We want the property to go to down to us like it should, with the use of fruct in favor of mom if need be. And everybody agrees to it, and it's just filed in the records, the conveyance records of the clerk's office. Doesn't require the judge's signature. Generally a much cheaper way to do a succession. So if it's applicable, meaning if it's just, mom and dad's house and a bank account and really not a lot of property, they're just good old folks, didn't have a lot to their name, and everyone's kind of on the same page, it's much simpler and easier to do a small succession. Not really favored by a lot of people who do title work and stuff, but it is generally a cheaper route and an easier route. So that's kind of the process. The first question is will or no will. If there is a will, you have that process. If there's no will, you have to do an intestate. If there is no will, next question is everything worth less than $125,000? If it is, you might want to consider doing a small succession by affidavit. If it's not, you'll need to file an intestate succession. So that's kind of the process. If you have any questions about that, or more importantly, if someone has recently passed away, you're trying to get the property done, the estate, as it's called in other places, the estate settled, and you're in North Louisiana, give us a call, Yoakum Law Firm, number right here, 318-639-9070. You obviously can always check us out online, www.idon'tsettleforless.com. No punctuations, just idon'tsettleforless.com. Follow us on Facebook, Instagram, social media. Click that like and subscribe button below. Share this with someone who may be interested in trying to figure out the process of what happens when mom and dad or someone passes away. And if you have any questions or need that done, call, set up a consultation with us. We'd love to help out. And stay safe and stay salty. That was stupid, but oh well. See you later.